Think of an author, and you probably picture a novelist hunched over a typewriter or a painter standing before a canvas. We rarely apply that word to a graphic designer building a website or an ad agency pitching a new layout. We tend to see that latter group as service providers doing a job. But Belgian copyright law ignores this cultural class divide. The legal code treats both the painter and the web developer exactly the same. The entire system hinges on a single core threshold: originality. If a commercial project, whether it's a corporate logo, an app interface, or a clever marketing layout, is the creator's own intellectual creation, reflecting their personal choices, it legally qualifies as an authored work. There is no sliding scale of artistic merit here. The law doesn't care if the work is considered noble art or purely utilitarian. It's a simple pass or fail checkpoint based on whether you made specific, personal creative choices. Holding the legal title of author creates immediate legal and financial leverage. It provides the specific rights needed to control how your work is used and functions as a distinct asset that qualifies for a lower tax rate. Yet, commercial creatives routinely leave this money on the table. They walk into legal traps simply because they fail to distinguish the value of the time they spent working from the value of the intellectual property they actually created. Protecting your commercial work and maximizing your income requires recognizing your dual identity. You are both a laborer providing a service to a client and an author generating a distinct legal asset. In the visual arts, a single creation rarely relies on just one form of legal protection. Instead, legal rights stack on top of each other. Take a corporate logo. It's protected simultaneously by trademark law for the brand, design rights for its shape, and copyright for the artistic expression. Because these layers operate independently, acquiring the trademark doesn't mean a client automatically secures the underlying copyright. This leads directly to the handover trap. Many clients assume paying an invoice automatically transfers the copyright from the creator to the buyer. It doesn't. Under Belgian law, any transfer of copyright must be explicitly documented in a formal written contract. The chain of title has to be traced back to every single contributor who worked on the project: the freelance illustrators, the freelance copywriters, and the graphic designers, not just the agency that sent the final invoice. Without explicit written transfer agreements mapping out the entire chain of creation, the client is merely buying a physical or digital product. The creator retains total legal ownership of the underlying intellectual property. But even if you do everything right and transfer the financial rights perfectly, there is another legal layer to consider: moral rights. Unlike patrimonial rights, which can be sold or licensed to generate revenue, your moral rights are inalienable. They remain permanently attached to you as the creator, no matter what your contract says. Practically, this means a client cannot legally disfigure, distort, or mock your advertising campaign in a way that damages your professional reputation. Since your reputation cannot be bought, commercial contracts must proactively negotiate acceptable adaptations and formats before the work is handed over. All of this civil protection sets up a massive financial reality. Because the commercial creator is legally an author, the income generated from ceding these copyrights qualifies for a highly favorable tax regime compared to standard professional income. The catch is that this significant tax benefit applies exclusively to the concession of the rights. You cannot apply it to the standard labor, the client meetings, or the mechanical execution required to actually build the project. To use this system, you must apply a method called ventilation, or mixed remuneration. This requires cleanly splitting every invoice into two distinct parts: the fee for your professional services and the royalty payment for the intellectual property. This presentation slide shows what tax authorities look for during an audit. They rigorously scrutinize the copyright concession, asking explicitly if the price is justified. Faking this split with arbitrary ratios to maximize tax benefits can trigger a full audit for tax abuse. Arbitrary invoicing is a dangerous fiscal trap. Securing this financial advantage is entirely dependent on your ability to prove a logical, legally defensible split between the act of creating and the asset you created. To survive an audit, creatives must proactively defend their ventilation ratios with rigorous internal documentation. The burden of proof is on you. That means keeping granular timesheets to track the exact hours spent on research and creative development, utilizing exhaustive written transfer contracts, and in some cases, securing advanced tax rulings to lock in your legal standing. Managing commercial art as a dual identity asset requires a professional approach to documentation. This rigorous approach ensures you protect the underlying intellectual property while securing the financial benefits that come with it. Please note, the information in this video is provided for educational purposes only and does not constitute formal legal or tax advice. Always consult a qualified professional regarding your specific situation.